The Act, which has the nickname HIPAA, was passed in 1996, and its purpose was to create ways in which individuals' protected health, their private health information, could be protected and not shared with the world inappropriately. And another purpose of it was for practices to become more efficient. A third related purpose that we don't think about so much because we're concentrating on the privacy and security portions of HIPAA is that it also affects the portability of insurance. For example, if you have a job and your insurance is something that you acquired through your job, it should be portable so that when you have another job, you can take your insurance with you. But that's not the focus of what most medical practices think about with HIPAA. Absolutely. At the very outset in 2002 and 2003, when HIPAA was first passed, the government was very lenient. The goal at that time was just to get everybody understanding what this was and how it works. And there was, although there was enforcement and penalties in there from the very outset, there was not an attempt to really audit and penalize people. Well, as the years have passed, we're now about 11 years after privacy and security passed, the government's program and focus has really changed significantly. Small practices are very much a target of investigation for compliance. They are certainly not out of radar range. And I'll share with you an interesting detail that came to my attention not too long ago. I was called by a small practice, and the practice had submitted an application for the financial incentive that was available under meaningful use. Under meaningful use, stage 1, you are supposed to attest that you're HIPAA compliant. So the practice said, yes, of course we're HIPAA compliant, but it wasn't really. The government turned around, and for one reason or another, either because somebody complained or it was simply happenstance, it came back to this very small practice and said, you're not HIPAA compliant, and not only do you have to be HIPAA compliant, but we're taking back the financial incentive that we already gave you. So you don't want that to happen. You really want to comply with the Omnibus Final Rule, the 2013 rules. Well, I think I just answered that question. I really answered two questions in one. There are both civil and criminal penalties if there is a violation of HIPAA. And enforcement is likely to change going forward because effective 2013, business associates are liable for compliance with respect to the security rules. So we are probably going to see not only medical practices, but those who qualify as business associates also getting penalized for non-compliance. All right, so first of all, PHI, as you know, is protected health information. And I'll give you a couple of examples, not a complete list, of the way in which this Omnibus Final Rule protects individuals' PHI. So one change that's rather important is historically a patient could request information, medical record information, PHI, from the physician. And there was no prescription about how that had to be given to the patient. And in most cases, it was copied and perhaps faxed to the patient. The new rule says that the patient has every right to ask that the information be provided electronically, and that the practice or the covered entity has to respond by doing what the patient asked. There's no specific way of responding electronically. The easiest way to do it would be to have a patient portal linked to a practice website, and then the practice would put the information that's requested in that secure patient portal and give it to the patient that way. But there could be other electronic ways that the practice shares information with the patient. So that's a big change in 2013. Another one that's quite important is if I, as a patient, receive a service from my physician, my covered entity physician, and I pay in full for that service, and I ask that the physician not submit information about the provision of the service to my insurance company. The physician is obligated to honor my request. So that's different from the way it was before, and most people will probably use it for care that is related to psychotherapy or addiction. Those would be the kinds of things that you might not want your insurance company to have. Prior to the passage of the Affordable Health Care Act, there were a lot of decisions made by insurance companies that would discriminate against people who had claims in certain areas. And behavioral health would have been one of those, addictions would have been another one. So again, if a patient says, I don't want the insurance company to have that information, now the covered entity has to comply with the patient request, so long as the patient pays in full for the service. So those are two examples. Another one that's less prevalent has to do with marketing, sales, and fundraising. If a covered entity would like to use protected health information or PHI for any of those three reasons, patient permission, written permission, is required first. So again, it's not a full list, but it gives you an idea of some of the things that have been changed. All right, so I'm actually going to read this to make sure I don't get this wrong, because it's very easy to make a mistake. But a breach is a mistake, an unintentional disclosure of protected health information. And the definition of a breach definitely changed in 2013. It's nowhere near what it was in 2009 when the concept was introduced. So as of 2013, if you think you have made a mistake in disclosure of your protected health information, ask yourself 4 questions. The first is the nature and the extent of the PHI, including the types of identification and the likelihood that it could be re-identified. The second has to do with who's the unauthorized person who used the PHI or to whom the disclosure was made. The third is whether or not the PHI was acquired and actually viewed. And the fourth is the extent to which the risk to the PHI has been mitigated. So let me use an example. It's a very common example that I think helps people understand what a breach really means. Supposing you go to the airport, you have your laptop computer with you, and it has on it protected health information. You're in a great rush. You leave your computer at security, and you're at the gate when you hear the public address system call you to come back and retrieve your computer. So if I were to ask the question, is this a breach or not, the answer really is not yes or no, it's maybe. And you have to ask yourself those questions. So, for example, perhaps it was never taken out of the case, perhaps nobody opened it, perhaps nobody accessed it, and nobody really had the opportunity to view any PHI on there. So it wasn't a breach. And it's just a lucky situation for me if that's what happened, and I want to make sure that it doesn't happen again. So I'm going to take steps, whatever they may be, to make sure I don't leave that computer at security again. Breach is, again, it's very different from what it was before, and if there are more than 500 people who've been affected by a breach, you have to notify all of them, notify CMS, and you will also put a notice in the newspaper to make sure that the public knows that there has been a breach. There have been a number of breaches in my community, the Raleigh-Durham, Chapel Hill area of North Carolina, and there have been articles in the newspaper, and I don't know about anybody else, but I certainly remember exactly what healthcare providers had those problems, and I would think seriously about getting my care there, because I don't like the idea of my records being spread all over the place. So that's the long answer to your short question on the breach. Absolutely. So, of course, the NPP is the Notice of Privacy Practices. And because of all these changes, you definitely want to have an NPP that is compliant with 2013 changes. So some practices have been through many versions. They had one when the Privacy Rule went into effect in 2002. They changed it in 2009 when the rules changed in that year, and now it's on to a third set of changes. So what I generally say is just tear up what you had originally and start again, and make sure that all the provisions that were new in 2013 are in your Notice of Privacy Practices. I also suggest when you give it to patients, what you want to do is make it available for them to read. And you could put a short cover letter on the top of it that says the rule has been changed. These are the highlights of what's changed, and we'd like to give you the opportunity to read it. You don't have to give it to everybody. They simply have to have the opportunity to read it. They sign to say that they have had the chance to read it, or if they choose not to read it, they also sign on a different piece of paper and say that they have chosen not to read it. But most people are accustomed to the Notice of Privacy Practices these days. They don't read it, and they quickly sign. Again, long answer to a short question, you definitely need a new and compliant Notice of Privacy Practices.